Okay, I'm recording the class. Welcome, everybody. Results for test 2, the online test, looked good. I was quite happy with those. The majority of you should have qualified for the exam by now. In order to qualify for the exam, you add your test 1 results, the percentage, add that to the test 2 results, the percentage, and divide by 2. If it's over 40%, you have qualified for the exam. Special test is only for students who have not yet qualified. So students who either missed a test or after 2 tests have done so poorly that they have not yet managed to get 40%. Then you may write Saturday's special test. You may not write Saturday's special test in order to improve your results. Test 1 has been entered on the kiosk. Test 2 results currently available on e-learning. I have asked student support to enter those results on the kiosk. They don't magically on their own jump from e-learning to the kiosk. The 2 systems are not connected, but that will happen shortly. But you can access your marks on e-learning and then test 1 on the kiosk. Okay, we're still busy with partnerships. Just give me a second. Okay, let me share my screen quickly. Okay, just give me a thumbs up if you can see the screen. It's the page that I normally use to type on. Just give me a thumbs up if you can see that. Thank you, Benjamin. Okay. So we're doing partnerships. What we've learned so far is what a partnership is, what the requirements are. We've learned that a partnership is not an entity. It doesn't have legal personality. It isn't a juristic person. It is a legal a legal relationship arising from a contract between 2 up to 20 persons. Ultimately, at the end of the day, these persons, these partners, remain liable for the debts of the business, for the debts of the partnership. That is very important. Then we looked at the 3 essential elements: contribution, joint business, and profit sharing, to learn more detail about what that entails. So moving on today then, to look at the rights and duties of partners. When we did purchase and sale and lease agreements, we learned that there are certain duties, rights and duties. We looked specifically at the duties when we were doing purchase and sale and lease agreements. Certain duties that flow from a particular contract because it is a particular type of contract. Because it is purchase and sale, there is the passing of the risk rule. Because it is purchase and sale, there is the guarantee against duty to guarantee against latent defects, etc., etc. Now, for partnerships, from a partnership agreement, there are also certain duties that arise because this agreement is a partnership. Unlike purchase and sale, where you have a purchaser, a seller, and a purchaser, in partnerships you have partners. They all have the same rights and duties. Rights and duties are linked together, discussed in the same unit purely because, obviously you know this by now, for every right there is a corresponding duty. So if partner A has a certain right, partner B has the corresponding duty. If partner B has a duty to do something, partner A has the right to expect of partner A to do that duty. So rights and duties then discussed at the same time. First duty is the duty of good faith. This is a very, very, very important duty. What you also need to understand is that the duty of good faith is not peculiar to partnerships. The duty of good faith is also known as a fiduciary duty. This is not unique to partnerships. Any circumstances where one person is entrusted to deal with property belonging to another person, there is a duty of good faith. It's very important that you grasp this. Next semester, when you do company law with me, we will be getting back to the duty of good faith, because company directors have a duty of good faith. Similarly, when we do close corporations, you will learn that members of a close corporation have a duty of good faith. So you need to understand this duty now. Next semester, I will take it for granted that you already understand and you know what good faith means. So firstly, I need to point out that the law takes this duty very seriously. It is a duty of utmost good faith, the highest level of good faith. Now, good faith is sometimes difficult to define. I can't give you a definition saying this is what good faith is. It entails a number of aspects. It entails that partners must promote the business of the partnership unselfishly. And they may not make a personal profit at the expense of the partnership. They must avoid a conflict of interest. They may not use any information or business opportunity which they've obtained through the partnership for their own benefit. If this is going to be detrimental to the partnership. Business opportunities that are in the scope of the partnership must be shared with the partnership. They cannot keep that to themselves. Goes very wide, as you can see there. Important aspects here is at all times they must act unselfishly. You can add to this, and in the best interest of the partnership. So to just give some examples, first of all, what you need to understand here is partners in a partnership have this duty of utmost good faith. This does not, however, mean or imply that you have to devote yourself to the business of the partnership 24/7. You may have outside business interests as long as it doesn't conflict with the business of the partnership. For example, if Marilyn is in a partnership that does accounting, she may not have private clients that she does accounting for after hours from her house and charges them for. Because it's the same business, those clients must be shared for the partnership. But that does not mean that she may not have an interest in a shoe shop. Yes, Evelina? Evelina, your hand was up.
Sorry, Miss Priest.
Okay. Yeah, so you don't have to spend all your time devoted to the business of the partnership. As long as what you do outside of the partnership does not take business away or does not, let's say, Benjamin, to use Benjamin here. Let's say Benjamin is a partner in an accounting partnership. But Benjamin also has a farm. So during the week, he works in the accounting business, and Over weekends, he goes to his farm. There is absolutely nothing wrong with that. That is not a breach of good faith. But let's say Benjamin and his partners share the profits equally. His partners are Dinalao and Colin. They're equal partners, they share, each get a third of the profits. Now, as time goes by, Benjamin starts spending more and more and more time on his farm. Instead of leaving on a Friday and coming back on a Sunday so that he can be back at work on Monday morning, he starts leaving on Wednesday and only coming back on Monday or maybe even Tuesday. So instead of spending 5 days a week working towards the business of this accounting partnership, he's now spending 5 days a week on his farm and only 4 days, maybe even just 3 days working towards the business of the partnership. So Dinalao, but he still wants a third share of the profits. Dinalao and Colin, are you going to be happy with us? Are you going to think this is okay? Because the two of you are working 5 days a week to make the money. Anybody that wants to answer, do you think that situation that I've just described, do you think that's okay?
Oh, that's unfair.
It's unfair. Thank you, George. It's unfair. Benjamin is not acting in the best interest of his partners and the partnership. And that could be seen as a breach of his duty of good faith. If he were to agree with Dinalao and Colin that, okay, I want to spend much more time on the farm, I will reduce my profit sharing and only take 10% of the profits rather than a third of the profits. Then, and they're happy with this, and then everybody's happy, that could be fine. So it's difficult to say exactly when is something a breach of good faith or whatnot. It depends very much on whether the other partners are okay with this behavior or not. Evelina is a partner in a shoe shop. And then she finds out that there is a shoe factory that is busy closing down, and they are selling their stock at a reduced price. Instead of acquiring this stock to be resold by their shoe shop partnership, she acquires it in her personal name and starts selling it out of her garage. George, is that okay or not? What do you think?
That is not okay.
It is not okay. It is a breach of her duty of good faith. Partners must at all times act in the best interest, with the interests of the partnership business must be upfront. What are the consequences of a breach of this duty? The law takes this very seriously. It can be grounds for the dissolution of the partnership. Any financial losses, damages or financial losses suffered by the partnership as a result of the breach can be claimed and then this last one, this is something which is peculiar to the duty of good faith, that any profits made not shared by, shared with. So to just illustrate this, let's get back to the shoe shop. Who was it? I can't remember who I use as an example. Marilyn. Marilyn bought these shoes and started selling them out of her garage. The business, the shoe shop, didn't lose money. They didn't suffer damages, but she made a profit out of her breach of her duty of good faith. That profit that she made, the remaining partners can actually get a court order that she shares this profit with them. I can illustrate this from an actual court case. It doesn't relate to partnerships, but the principle is the same. It actually relates to company law, where there was a chappie who was the managing director of a company. And this company wanted to buy a property from somebody else. The seller of this property made it very, very clear that they would not sell this property to the company, to call it XYZ company, because of some beef that there was between the sellers and not the managing directors, but some of the other directors. There was some beef. The sellers made it clear that under no circumstances and for no money would they be prepared to do business with ABC company. The sellers subsequently approached the managing director and said to him, you know what? We have beef with the other directors, but we've got nothing against you. And if you are prepared to leave that company and go on your own, we will do business with you on your own. Which he did. Company that he left found out about this and took him to court for a breach of his duty of good faith. Now, the original company, ABC company, did not lose any money because the sellers had made it very clear that they were not prepared to go into business with them. They were not prepared to sell to them. However, because Mr. Managing Director Chappie was previously a director there and made this business contact while he was a director, court ordered him, found him to be in breach of his duty of good faith, and all the profits that he personally made out of going on his own and doing business with the sellers, he had to pay back to the company. Court takes the duty of good faith very, very, very seriously. Any questions about that? Okay. Next duty. The duty to act in reasonable care. What this means, the duty to act with reasonable care, is that a partners should avoid negligence. You know what the word negligence means when dealing with partnership affairs. Or partnership property. Now be careful here. The duty of good faith is a duty of utmost, the highest level of good faith. This duty is a duty of reasonable care. Do you see the difference between utmost good faith, the highest level of good faith, and reasonable care? Just like a reasonable, not utmost, most highest level of good care. That's not what is expected. Only thing that is expected is like an ordinary person would. They should treat the partnership property with the same amount of care their personal property. If you had to go into the court cases, recorded court cases, and look for cases dealing with these aspects, there are very numerous court cases dealing with good faith and where persons, not just partners, but also company directors, etc., have been found to be in breach of their duty of good faith. There are, however, relatively few examples of court cases where partners were found to be in breach of their duty of care, because the standard is not very high. Standard is not very high. You don't need any specific experience. You don't need any special qualifications to be a partner in a partnership. And now you must be careful. This is a word of warning. I give it every year, and students keep on making this mistake. And if I find this mistake in your forthcoming exam, I will penalize you very, very much. The duty of good faith and the duty of reasonable care are two distinctly separate duties. Let me just get back to this. If there's a breach, partnership can claim damages. These are two distinctly separate duties. Do not mix them up. Do not lump them together. What I see regularly is something like the fiduciary duty of care and skill. This is rubbish. There is a duty of care and skill, a duty to act with reasonable care. Put this in care and skill. And there is a duty to act with utmost good faith. These are separate duties. You can see the difference. Firstly, because of the level required. You have utmost good faith as opposed to reasonable care and skill. So the expectations aren't the same. Secondly, the remedies. Breach of good faith. Any profits must be shared with the partnership. Duty of care and skill, only damages. Do not, be warned, I will penalize you most severely if you ever write about the fiduciary duty of care and skill. They are different duties. Questions? Okay, next duty. You would think this is fairly self-explanatory. Remember, I told you last week when we were doing partnerships, when we started with partnerships, that there is a lot of overlap between the separate units. We looked at the essential elements and we saw that okay, it wasn't there. Let's go further up. That one of the elements is that business must be carried on for the joint benefit of the partners. This is pretty much a repetition of that. Can't just enter into a partnership agreement and then do nothing. You must actually do what you undertook to do. Partners must commence the business as agreed. And a big part of this is that contributions. If your contribution is your car, you must actually make that vehicle available. If you undertake to contribute $1,000, you must actually pay that $1,000 over. So you must do whatever you have set out to do. In general, partners are not to compensation for work done, for services rendered. Because the compensation lies in the profit sharing. So in order to share in the profit, you have to do the business, you have to deliver the services. Otherwise, there isn't going to be any profit. You don't get paid for your services as such, but you do get a share of the profit. Note that I have said in general. The moment I say in general, it means there are exceptions. Partners are free to agree otherwise. Always keep in the back of your head that a partnership is a legal relationship arising from a contract, legal relationship arising from an agreement. So if they agree that one partner who does a bigger share of the work will receive a salary for their work done, then that's 100%. Nobody's going to say they may not do that, as long as it is by agreement. Partners can claim compensation for any additional extra tasks done. And of course, if they covered expenses from their personal pocket. So if you are driving a vehicle that belongs to the partnership, and this vehicle breaks down while you are in Hana, for example, and you have to have it fixed, and you pay to have it fixed out of your own pocket, you can claim that money back. So partners have a duty to carry on the business of the partnership. They are in general expected to do this without seeking compensation for this, because their compensation lies in profit sharing. But there are exceptions to this task, to this rule, whatever is agreed upon between the partners. Questions? The duty and the right to share in profits and losses. Essential element of a partnership. Let's go back up. The object is to make and share a profit. How are these profits shared? And be careful with this. If I ask you in the exam, how are profits shared? There is a particular rule. This rule works in a particular manner. You have to list it in sequence. So how are profits shared? So what percentage of the profits does every partner get? As per their agreement. So if my partners are Evelina, Dinalao, George, and Benjamin, and they have agreed between them that Evelina will get 70% of the profits and didn't allow George and Benjamin 10% each, then that is how it will work. Because, and don't say, but it's unfair. That is their agreement, and it's not up to me and you to say that's wrong. That is what they agreed. That is what they are happy with. So profits are shared, and this agreement does not have to be linked to the value of the contribution. Profit sharing and contribution are separate aspects. Profit is shared in the manner that they decide to share their profits. If there is no agreement, if they did not specifically agree how to share profits, the default rules come into action. And they will share according to the value of their contribution. So in that case, the partner who made the bigger contribution will get a bigger share of the profits. If, however, the contributions cannot be valued because one partner has donated property, there's a value on that. The other partner donates money, there's a value on that. But the third partner donates their labor, their work. How do we value their labor? How do we put a price on the labor? So if the contributions cannot be valued, only in that case will profits be shared equally. Are you with me? If I ask you to list the rules regarding profit sharing, you need to list them in the sequence. Don't tell me they share equally and then afterwards say they share according to their contribution. There's a sequence in which this is done. It's according to the agreement. There's no agreement. It's according to the value of the contribution. If the contributions cannot be valued, they will share equally. Now, what about losses? How are losses shared? Firstly, losses are also shared in accordance to how they agree to share their losses. And note, the sharing of losses, the agreement with regard to the sharing of losses does not have to be the same as the agreement with regard to the sharing of profits. They can, Evelina didn't allow Sophia and Benjamin can agree that they will share profits equally. But with regard to losses, Evelina will carry 70% of the losses and the rest of them 10% each. Once again, don't sit here and say, but that's unfair. It might sound unfair to you, but that is their agreement. And if they agreed upon it, it is not up to us to say, you can't do that. That is their agreement. So there can be a separate agreement. There's one agreement about how do we share profits. There can be a separate agreement about how do we share losses. If, however, if there's no agreement about the sharing of losses, then losses to be shared in the same manner as profits. Other words, like that. So you first look, is there a specific agreement about sharing of losses? If there isn't, then you look at how do they share profits. If there's a specific agreement about sharing of profits, losses will be shared in the same ratio. If there's no agreement about sharing of losses of profits, profits are shared according to the value of the contribution. Similarly, losses are shared according to the value of the contribution. If the contributions can't be valued, then both profits and losses will be shared equally. Be careful about this. If you ever enter into a partnership agreement, think carefully, because this aspect can have far-reaching consequences. If losses are shared in accordance, in the same manner as you share profits, the partner who made the biggest contribution gets the biggest part of the profit. That makes sense. The effect of this rule is that the partner who made the biggest contribution will also share in the biggest part, the biggest portion of the losses, which can have very unfair implications. So make sure that if you're entering into a formal partnership, that you have in your partnership specific provisions regarding the sharing of losses, so that you don't end up having made the biggest contribution and having to shoulder the biggest part of the losses. Everybody with me? Next one, use of partnership assets. First thing that you need to understand, we've already looked at the partnership fund. So the partnership assets, essentially the partnership fund. Unless there is an express agreement to the contrary, partnerships are partners are co-owners. Partnership fund. Co-owners Partnership means, put that in here, joint co-owners. That means that they all own it together in undivided shares. Partnership asset, partnership fund will only be divided upon dissolution of the partnership, when the partnership comes to an end. While the partnership exists, partners are joint co-owners of the partnership assets. So if there is if Evelina and Dinalau are our partners, and there is $100,000 in the bank, that does not mean that Evelina has $50,000 and Dinalau has $50,000. It means Evelina and Dinalau together are the owners of 100,000. Evelina cannot withdraw her half while the partnership still exists. Joint co-owners in undivided shares during the existence of the partnership. Partners may freely use the assets for the purpose of the business. So partnership assets, anybody may use these assets for the purpose of the business. With regard to personal use, they are allowed limited use provided not conflict. So let's say the partnership has a vehicle which it uses as a delivery vehicle. And Samuel was using the vehicle during the day to do deliveries. Come lunchtime, he quickly stops at his child's school to collect his child from school, take her home. End of lunchtime, he's busy carrying on with the business of the partnership. So he's used the partnership vehicle to take his child home from school. That is fine. Nothing wrong with that. He's allowed to do that. That limited use did not conflict with the partnership business. He cannot, however, take the vehicle belonging to the partnership in order to go on holiday for a week. If he does, a partner who abuses partnership property can be charged with theft. And then the last duty that is listed here in Unit 13 concerns management of the partnership. I am not going to do that with you now because we do that in more detail, in great detail, in the next unit. In Unit 14, we deal with the management of a partnership and contractual liability of the partnership. So that's the end of what I wanted to do today. Any questions? No questions. Benjamin?
Yes, ma'am. It's actually just a general opinion
Please go
about
ahead.
the notes. Yeah, the notes you are making in the classes. They are no more being posted on the group.
Okay, I did not share them before test 2, but I
Mhm.
will. We have got two more units to do, 13, 14 and 15, which we will finish next week. And I will then tidy them up and share them with you for your exam preparation purposes, I promise.
Okay, madam. That's all.
Yeah, no, I will share my class notes with you once we've finished everything, once they are complete, so that you can use them as a sort of a framework when it comes to your exam preparation. I will advise you of the time. It will be before exams start, after the end of classes, but before exams start. I will host an examination preparation class where I will go through the layout of the exam with you and exam tips and guidance for the exam, what to concentrate on, etc., etc.
Miss,
Okay, Evelina?
would it be possible to somehow set on e-learning for test 2 so that we can review?
Come again? Would it be possible?
Like currently, I'm not able to review the test 2 that was online.
Oh, I will go and look at the settings. Thank you for pointing that out to me. You should be able to review your test. So I probably did something wrong in the settings. I'll just go and check on that this evening and make sure I fix that so that you can review your test. You should be able to
I
do
think
that.
it's on her end. I think it's on Evelina's end because I can review my test.
Was it exactly after the test? Because after the test I could review, but today I tried again and I couldn't.
But I think there's a notice that went out that Nasty's saying something about e-learning that is having problems.
Is it?
No, that was ITS. That was the kiosk. Okay, thank you,
No, ma'am,
Rushay.
e-learning.
Is there a problem? Okay, I haven't seen a notice about a problem with e-learning. I will go back and check the settings. You should be, because you need to have. I will also, after the special test is tomorrow, but closer to the exam, I will set up a practice quiz again for students that want to practice their multiple choice. So I will check whether there's a problem with the system in general or just a problem with the settings. Thank you, Rushay. Thank you, Evelina. Okay, anything else? Otherwise, have a wonderful Wednesday evening and a blessed weekend. I will see you next week then. Bye.